So we talked briefly about MERS. MERS is a registration system created by all the major banks, and it's a registration to bypass and bypass the county recorder's office, A, to save money, and B, to keep everything private. And if it's private, then it's not official. And so what happens is when the time is right, so they go through, they have their millions of different individual transactions internally that God knows, nobody knows what happens in the MERS title. And once an action is ready, they then appoint a party to foreclose on your house. It makes as much sense as your county recorder appointing his friend to own your property. A county recorder, their job is just to record information. The job of the county recorder is not to assign title. So yet on your deed of trust or your promissory note, MERS is oftentimes, if your instrument is securitized, MERS is named as a nominee, and sometimes they're named as a beneficiary. Now, they're not a true beneficiary because they never funded the instrument, they never funded the note, they never gave any money. So if they're not given, they didn't fund the promissory note, then they're not a true beneficiary. So they're just made up beneficiaries for the purpose of private recordation. Now, the other thing that can be proven is they never received any payment because they were never a holder. So those two things disqualify them as a beneficiary. Now, the other thing you have to understand is for $300, anyone can register with MERS and become a vice president of MERS, giving anyone the power to assign any title in the MERS pool of notes that they track to anyone that party wants. There's absolutely no authority whatsoever. I mean, basically anyone can have authority over any mortgage whatsoever simply because they are a vice president of a MERS. And so that's what you have to understand, is that's not a real vice president. It's a vice president in title and purpose only, and not in power. And what happens is MERS then appoints a substitution of trustee on your deed of trust, and they appoint the assignment of the deed of trust or the mortgage. And like we said, MERS do not have the power to do that because they are not the beneficiary. Only a holder in due course have the power to assign anything to anyone, whereas MERS is just some registration system. The other thing about MERS you have to understand is that it's ruled many times in court that MERS has no authority to assign title. And if they have no authority to assign title and they do it and they record it, they have therefore clouded your title, and the recordation of fraudulent documents is illegal in almost every state that I know of. It's illegal. So they're committing fraud. Okay? So you can use this argument then in your legal defense in a quiet title action or in a wrongful foreclosure suit. Simply just using our kit, that all the information in the reference directory will show you how to quote case law to use the fact that MERS have not had any authority to do so, yet they've done it, therefore they've broken the law. Now let's talk about robo-assignments. We mentioned earlier that blank assignments are done as a standard bank practice, and sometimes what they do is they give blank assignment promissory notes to these foreclosure mills, and they give these foreclosure mills the robo-signers, and the robo-signers reverse engineer the chain of title that is sufficient to do the foreclosure. And so they basically backtrack and fix the defect before the facts. The thing is, they also have to write an affidavit of assignment, stating that they know firsthand that this is a legal assignment. Well, this is in a foreclosure mill, okay? It's a separate operation from the original bank. So how do they have firsthand knowledge? They don't, but they say it in an affidavit, and when they put it in an affidavit, the court accepts it on face value unless it's contested in a deposition. Okay, these people are actually openly committing fraud. The other thing that these assignments are done is they have a notary. They're supposed to have a notary present. Remember, on the language on the notary says appearing before me. Well, the notary is not even present. It's in another department, another store, another place. And what happens is oftentimes the date signed on the deed of trust for the assignment is a different date than the date of the notary, typically 1 to 7 days. And so if the notary is not present and the notary says that that person is present before them, then we have a situation of notary fraud. The other thing that these people do is they have the notary signature and they pass it around like a first grader stamp. They just pass it around and they stamp, stamp, stamp. So the signatures don't match, and they get their friends to sign on behalf of the notary. So the signature do not even match that is registered at the state level for the notary. So we have a situation of notary fraud as well. The other thing that is standard practice for these organizations is, remember we said assignments of the deed of trust as well as the promissory note has to be done by an authorized party. Well, typically what these robo-signer or foreclosure mail outfits do is they have a registered official party, for example, Linda Green. If you Google that up, you'll find an amazing variety of signatures of Linda Green. And Linda Green doesn't even work for oftentimes these companies, and she's probably not even an employee anymore of any financial institution because of how abused her name has been. Okay, look up Linda Green. Okay, so remember, an assignment has to be done by an authorized party. So these people are trained to sign a different name. So they're not even Linda Green or that any authorized party, but they sign a rough scribble that doesn't even match that of that real person. So that's another thing that you have to look for. If you receive these documents, take a close look, okay, and Google them up and see who they are, because if they are not who they say they are, then they're committing fraud, and that's another argument that you can put in place. So let's summarize. Okay, in order for the foreclosure to be perfect, the party doing the enforcement has to demonstrate perfection both in the deed of trust as well as the promissory note. So you have to learn to demand, if you are in a judicial state, the perfection of chain of title on the promissory note as well as the perfection of chain of title on the mortgage. If you are in a non-judicial state, you have to then file a civil action and demand the perfection of title on the promissory note, the perfection of title on the deed of trust. Unfortunately, as a plaintiff in a non-judicial state, in order for you to bring a civil action, you need to have evidence. And one way you can do evidence is through what we call evidence of movement. In other words, bank assigning from bank A to bank B to bank C. There's clear movement. Or you get them to admit that they are a servicer, so therefore they have somehow sold the note. The other thing is you can also get is a securitization, and we recommend highly that you get a securitization audit anyway, because a securitization audit will show lots of defects that you can bring up in your foreclosure defense. The other thing you want to demonstrate is that state law has been violated, because state law requires that parties need to record their interest in real estate in the local county recorder's office. Therefore, bifurcation have occurred. Therefore, the deed of trust terms have been violated, making the deed of trust or mortgage defective. The other legal defense you want to use is MERS has no authority. It's been proven over and over in state and federal courts that MERS have no authority, and if they have no authority and they've assigned it anywhere and recorded, that's almost like a picture of a guy holding a gun at the bank. It is evidence that you can use of foul play in your foreclosure defense.